Welcome back to another edition of Between Two FARS. I'm Warnke Miller here once again with the amazing Robert Tepfer, and Bob is talking to us about the principles of contract interpretation. And it's very important that you watch this entire series because this really is just about a weighing of the equities and a look at the totality of the circumstances of your particular contract and the particular dispute you're having with its interpretation. But in order to get to that point, we do need to talk about the different principles and how they apply to your contract. So today, Bob, why don't we talk about all of the complexities that come with that order of precedence clause in your contract?
Yeah, the order of precedence clause would seem to straighten out a lot of things. It tells you which will control if there's a problem. The fact of the matter is, though, if there's a real problem and that there's a conflict between the various sections, that notwithstanding the order as stated in the FAR clause, you may find out that the prior rule of patent ambiguities may trump the clause, and there may be a contractor obligation to come forward, notwithstanding the fact that there's an argument, hey, why would I have come forward? There is no contradiction because the language in the order of precedence clause resolved it. And you would even argue theoretically, hey, you charge me with reading the contract as a harmonious whole, read the plain language, read the entire contract. And when I do, it includes the order of precedence clause, and it resolves the matter. But some of the cases seem to indicate that if there's a patent ambiguity, the contractor had a duty to come forward, speak to it, and ask the question. So, the clause is good, but I'm not certain it is the panacea that you would like it to be. And for that reason, you've mentioned the fact that, the totality of circumstances, the equities involved. I would recommend that if you have more than one principle, that you point to those along with the order of precedence clause and show why your conduct was reasonable in relying on your interpretation and those particular principles. Have more than one principle is what I would say.
Yeah, so just because you've got the order of precedence written into your contract, don't think that it's going to resolve all of the ambiguities or interpretation issues.
It's definitely not a get out of jail card if there's an outrageous problem there.
That's right.
If you're the contractor.
Well, we've got some more contract interpretation principles to address before we can go and look at the holistic way that all these principles fit together. So why don't you come back for the next edition of Between Two FARS when we talk about extrinsic evidence.